Hello and welcome to Courts Today by Live Law. Let us get to today's top updates. A Kolkata court has sentenced convict Sanjoy Roy to life imprisonment in the Archika rape murder case. A Kerala court has awarded death penalty to Greeshma for murder of her beau Sharon Raj. The Supreme Court has asked Jammu and Kashmir and Ladakh High Court to install proper VC facilities in Jammu court holding trial against Yasin Malik. In the Badlapur Fake Encounter case, the Magistrate Inquiry has concluded the 5 policemen responsible for accused's death. The Kerala High Court has issued Bailable Warrant against Patanjali Ayurved's Baba Ramdev and Managing Director in Misleading Advertisements case. The Supreme Court has given last chance to the union to decide on Balwant Singh Rajoana's mercy plea and has posted the matter to 18th March. The Apex Court has stayed proceedings against Rahul Gandhi in criminal defamation case over remarks against BJP and Amit Shah. In the Lakhimpur Kheri case, the top court has asked Uttar Pradesh police to inquire if Ashish Mishra, who is on bail, attempted to influence witnesses. And the Apex Court has said that police arresting accused after filing charge sheet and court's cognizance makes no sense. This is your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Let us start. Starting with a significant development, a sessions court in Kolkata's Aselda today sentenced prime accused Sanjoy Roy to life imprisonment in the Arjika rape and murder case, wherein Roy was accused of brutally raping and murdering a trainee doctor after her night shift. Roy was found guilty under Bharatiya Nyaya Sanhita for offences of rape, causing injury resulting in death of rape victim and murder. At the hearing, Roy had claimed his innocence and stated that he was not involved in the incident. But the court did hold him guilty of the rape and murder of the trainee doctor. For this, the court relied on forensic reports which pointed to involvement of Roy in the incident, placing his DNA at the scene and on the deceased doctor. While pronouncing the sentence today, Sessions Judge Anirban Das held that the case did not fall into rarest of the rare categories, warranting a death sentence. Also, the state government has been asked to pay the victim's family a compensation of 17 lakhs due to the fate suffered by her. In another important case, in the Sharon Raj murder case, a court in Kerala's Trivandrum has awarded death sentence to Greeshma, who was convicted last week for poisoning Sharon to weasel out of their romantic relationship. As per the case, Greeshma invited Sharon to her house and gave him an Ayurvedic concoction laced with poison. Her mother and uncle were also accused of destroying the evidence by concealing the bottle of poison. Greeshma has also been sentenced to 10 years of imprisonment for offense of kidnapping and abducting, to murder, and 5 years of imprisonment for destroying evidence. The court had acquitted her mother, but her maternal uncle was convicted for destruction of evidence. He has been given 3 years of imprisonment. The Supreme Court has directed the High Court of Jammu and Kashmir and Ladakh to immediately install proper video conferencing facilities in the Jammu court, where the trial of Kashmiri separatist Yasin Malik and others is being held. They are accused in the case related to the 1989 assassination of 4 Indian Air Force officials. The bench comprising Justice Abhay S. Oak and Justice Ujjal Bhuya was hearing a petition by the CBI challenging the Jammu court's order to produce Yasin Malik in person for the trial. The CBI has raised security concerns about Malik's physical presence in court, suggesting that the trial be held via video conferencing from Tihar jail, where Malik is currently imprisoned. However, the other accused objected to this, citing their difficulty of travelling to Delhi. Solicitor General Tushar Mehta argued that the accused were coordinating with Malik to complicate the trial location. The CBI emphasized that Tihar jail has functional video conferencing facilities, and so there is no need for Malik to be transported physically. The court today perused the report which stated inadequate video conferencing facilities in the Jammu court, after which the court gave the direction to the registrar. The bench stressed the need for proper facilities to allow effective virtual cross-examinations and requested a report on the new system by 17th February. Additionally, the registrar of the Delhi High Court was directed to examine the video conferencing facilities in Tihar jail, where Malik is presently undergoing life imprisonment in a terror links case. Moving ahead, in relation to a plea filed by father of the Badlapur school sexual assault accused who died in an alleged fake encounter, a magistrate inquiry report has been submitted before the Bombay High Court. Let me give you a brief background first. In August last year, a male sweeper was alleged to have sexually abused 2 4-year-old girls in a prominent co-educational school in Badlapur, Maharashtra. The accused was arrested after a case was filed against him under the POCSO Act. The case had led to widespread protests and significant public outrage. In September, the accused was killed in allegedly retaliatory firing when he was being taken from Taloja jail to Badlapur for an investigation into a fresh case that his ex-wife had filed. Reportedly, he snatched a service gun from the police officers and shot 3 rounds. Post this encounter, his parents approached the court and alleged it to be a fake encounter. A magistrate inquiry was conducted and the report of which was read out in open court today by the bench of justices Revati Moite Dere and Neena Gokhale. It said that as per the material collected and the FSL reports, the allegations of the parents of the deceased were justified and the 5 policemen were responsible for his death. The report stated that the force used by the 5 policemen in the altercation with the deceased was unjustified and that they were responsible for his death. That there were no fingerprints of the deceased on the gun. It stated that the police's stance that they fired in private defense was unjustified and under shadow of suspicion. Maharashtra's chief public prosecutor Hiten Venegaonkar today informed the bench that the state will act in accordance with law and register an FIR. In the next update, a Kerala court has issued a bailable warrant against Divya Pharmacy and its co-founder Baba Ramdev and its managing director Acharya Balkrishna in a case of publishing misleading advertisements in English and Malayalam newspapers. The next date in the matter is now 1st February. The complaint was taken based on the report of Drug Inspector under the Drugs and Magic Remedies Objectionable Advertisements Act under various sections like Section 3, which prohibits the advertisement of certain drugs for treatment of certain diseases and disorders. Section 3, Clause B, which prohibits advertisements of drugs claiming maintenance or improvement of the capacity of human beings for sexual pleasure. And Section 3, Clause D, which prohibits advertisements of drugs and claim the diagnosis, cure, mitigation, treatment or prevention of any disease, disorder or condition of diseases provided in the rules made under the Act. The warrant was issued after the Supreme Court warned states and union territories that it will initiate contempt proceedings on failure to take action against misleading advertisements and medical claims that run contrary to law. The Apex Court was hearing a petition filed by the Indian Medical Association regarding misleading claims and advertisements targeting modern or allopathic medicine. And now regarding the mercy petition filed by Balwant Singh Rajoana, the Babbar Khalsa terrorist who is seeking commutation of the death sentence, the Supreme Court has today asked the union government to take a decision by March or the court shall be deciding the matter. He was a police officer in Punjab and was convicted in 2007 by a special CBI court under IPC and Explosive Substances Act for an incident involving a deadly suicide bombing at the Chandigarh Secretariat complex in 1995, wherein the then Chief Minister of Punjab, Beau, along with 16 others, lost their lives. He is seeking commutation on the grounds of delay in considering the mercy petition pending before the President of India since 2012. His counsel, Senior Advocate Mukul Rohtagi, submitted today that nothing has happened since the last hearing where the court granted some time to the union. On the last hearing, Solicitor General Tushar Mehta had stated that the case involved sensitivities and therefore he had pressed for 4 weeks' time. Rohtagi today said that Singh had spent 29 years in prison with 15 of those years on death row. He urged the court to grant Singh some relief, emphasizing the importance of allowing him to reintegrate into society. He also criticized the prolonged delay in the decision-making process by the union, saying that it had been making same arguments about the case's broader ramifications over the past 5 years. In November, a special bench of Justices B.R. Gawai, Prashant Kumar Mishra and K.V. Vishwanathan had ordered the President of India to decide on the mercy petition within 2 weeks, but the order was not signed and finalized because Solicitor General Tushar Mehta, who was not present when it was passed, urgently requested the bench to hold off just before they were about to break for lunch. The bench had accepted his request and agreed not to finalize the order. Today, the SG pressed for 4 to 6 weeks more time, which the court said it would grant subject to the fact that in the next hearing, if the union has not decided the fate of the mercy petition, the court will hear the matter on merits. The case is now posted for hearing on 18th March. Stay tuned. In the next update, the Supreme Court bench of Justices Vikram Nath and Sandeep Mehta has today stayed the trial court proceedings in the criminal defamation case filed against Congress MP and leader of opposition Rahul Gandhi. The case was filed by BJP worker Naveen Jha, for Gandhi had allegedly said that Bharatiya Janata Party members were liars and drunk with power, and for calling Union Home Minister Amit Shah a murder accused. The interim order was passed by the bench while issuing notice on Rahul Gandhi's special leave petition challenging the Jharkhand High Court judgment, which dismissed his plea to quash this defamation case. Gandhi's counsel, senior advocate Dr. Abhishek Manu Singhvi, submitted that there are several judgments which hold that only the aggrieved person can file a criminal defamation complaint. He argued that the complaint cannot be filed by a proxy third party. Let me tell you, the High Court had held that Jha, being a party worker of BJP, had the locus standi to file the complaint. In another important development, the Supreme Court has directed the Superintendent of Police in Lakhimpur, Uttar Pradesh, to conduct a fact-finding inquiry into claims that Ashish Mishra attempted to influence witnesses in the Lakhimpur Kheri case. The case, as you know, involves the death of 5 people in October 2021 when vehicles in Mishra's convoy allegedly ran over protesting farmers. A bench of Justices Surya Kant and N. Koteshwar Singh issued this order while hearing an application from the victims' families seeking cancellation of Mishra's bail, accusing him of trying to intimidate witnesses. During the hearing, Advocate Prashant Bhushan, representing the applicants, argued that witnesses were being threatened. On the other hand, Senior Advocate Siddharth Dave, defending Mishra, called the allegations baseless and claimed that they were meant for publicity. He asserted that Mishra was at the Lok Sabha Secretariat on the day in question, providing an alibi. This case has been controversial since its inception, as Ashish Mishra's father, Ajay Kumar Mishra, was a union minister at the time of the incident. At that time, the Supreme Court had criticized the Uttar Pradesh police for delaying Mishra's arrest. He was granted bail by the Allahabad High Court in February 2022, but the Supreme Court later overturned this decision, stating that the High Court had ignored crucial factors. Then in January 2023, the Supreme Court granted Mishra interim bail with strict conditions, allowing him to stay in Delhi or Lucknow, and this was later made permanent. Today, Justice Surya Kant suggested a parallel inquiry to determine if the accused or someone else was responsible for influencing witnesses. The court emphasized that the police would verify the credibility of the allegations. The SP has been given 4 weeks to submit a report on the same. And lastly, the Supreme Court has criticized the practice of arresting accused individuals after the court has taken cognizance of the charge sheet, especially when they were not arrested during the investigation. A bench of Justices J.B. Pardiwala and R. Madhavan expressed surprise over this unusual practice, stating that it makes no sense. The court emphasized that once a charge sheet is filed, the accused should be asked to appear in court and provide bail rather than being arrested post-investigation. The bench pointed out that if the police needed to interrogate the accused, they should have done so during the investigation. Making an arrest after the charge sheet has been filed serves no purpose. This observation was made while granting bail to an individual in a case under Prevention of Corruption Act. The court noted that the petitioner was never arrested during the investigation, and thus there was no need for a formal arrest after the charge sheet was submitted. The court also referred to previous judgments like in Siddharth versus State of Uttar Pradesh and Satyendra Kumar Antil versus CBI, where it was held that the police are not obliged to arrest an accused at the time of filing a charge sheet. Thank you for watching. For more information on the cases that we discussed, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel.